Well, I'm waiting on a call for Omni Williams. Uh, I'm gonna correct today. I'm gonna definitely correct that heading, but I won't speak on what she's gonna tell me until she comes on live, and then I will get into it. But what I can say is that uh, I haven't seen it on the docket yet, but I do have the court order. I'll show that in a proceeding in a few. She has been granted a hearing on the motion for new trial that she filed January the 22nd, 2024. And they don't want to actually, they was forced. Well, you're going to see me in a little bit. I'm just getting set up. Had to make some coffee. Now, they have been interfering with the phone calls, stuff like that. And Matthew Seymour, which is her appealing attorney, he has did something very, very questionable. But it's not only is it questionable, it's decisive in the way he feels. But there's been some development, very bizarre developments in this case. And it's 12:01, so I'm still waiting on a call. So sometimes they'll interfere with the tablet that they give them, turn the Wi-Fi off. But I told her that if she didn't reach me today during the live, because we're supposed to go live today at 12, I said if she haven't reached me by 12:15, 12:10, I would pretty much know what was going on. The motion for new trial, all the videos that I did in regards in promotion of January the 22nd motion for new trial, the attorneys, the judges, the DA, they was all trying to circumvent that particular motion. But it posed a problem because once the trial court, I'm going to be specific when I say the trial court, once the judge, Tracy Holmes, instructed Patrick Crawford, a clerk of the court, to backdate and file stamp a notice of appeal for Omni Williams to circumvent her motion for new trial filed January 22nd, 2024. This was a criminal conspiracy at its finest. All the elements are there. And then when I chimed in and informed them that, well, Patrick Crawford is not Omni Moore's attorney, nor is this clerk job description. Job is to file notices of appeal for defendants. That's their attorney job. So if Patrick Crawford, which is the clerk of the court, what he did was invalid and it's questionable. So Philip Barton turned around and did a notice of appeal as well. Well, the problem with that is this. Philip Barton's notice of appeal is file stamped and backdated as well. And then Philip Barton, her trial attorney, filed a notice of appeal / motion for new trial. Now, here is the big problem with that. Because this is about, I'm still waiting on Omni Williams. There it is. Oh, come on, for real.
This is a free call from an incarcerated individual at Dallas County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept this free call, press 1. Thank you for using Securus. You may start the conversation now.
Hello?
Yes, hello?
Yeah, did you have any problem calling today?
No.
Okay, could you state your name and your felony case number if you have it on play? If not, just your name would do.
Okay, my name is Omni Williams, and my case number is F2221231.
Okay, I'm gonna have you kind of repeat that. You sound like you're coming in raspy a little bit to me.
Okay.
Go ahead.
Okay, can you hear me? Okay. Omni Williams, probably my throat's itching a little bit. I'm Big Williams, and my case number is F2221231.
Okay. Well, I'm gonna ask you a question. Can you tell me? I want dates. Can you tell me the phone call you had with your grandmother and the date that you had it? I just need you to give the details.
Yes, I had a phone call with my grandmother on February 29th of 2024 at approximately 4:45, 5 o'clock in the afternoon.
Okay.
Okay. And so when I was talking to my grandmother, she said that she talked to my sister, and my sister told her that she had talked to Matthew Seymour. And during the conversation with Matthew Seymour said that they were going to have to give me another trial because the first attorney, didn't do any type of defense or give me any type of defense during that trial. Okay, so then he went on to tell her that I'm going to go to prison, and when I go to prison, I'm not going to be able to talk to anybody for 45 days.
Well, I mean,
so
I'm okay. You said when you go to prison. I don't understand. You need to. I need some clarification.
What she was telling me was.
Go ahead.
I'm sorry. What she was telling me was that I was still going to go to prison. So I guess after this new trial that we're supposed to have, that they're already planning to send me to prison either way. So I'm wow.
Well, let me ask you a question. Are you telling me that your appealing attorney, Matthew Seymour, called your sister or your mother and told them they got to give you a new trial, but you're going to be found guilty again?
Now, I don't know if he said those exact words, but he said I'm going to prison. And he said that when I go to prison, that I'm not going to be able to talk to anybody for 45 days. And I don't even understand exactly why that would be or what that would mean.
Well, see, the problem with that whole thing is Matthew Seymour is your lawyer. He has no business contacting your mother or your sister because that's your attorney. So the fact that Matthew Seymour is reaching out to your mother who brought the complaint, that's a breach of fiduciary duty. And for him to say that you go on to prison and you won't be able to talk to nobody for 45 days, I don't understand where that's coming from. None of that makes sense to me. Well, let me ask you this here.
That's right.
Let me ask you this here. Now, have Matthew Seymour or anybody else came down there to talk to you concerning any witnesses that you if for any witnesses that you will be needing for the hearing for the motion for new trial on I think March the 21st?
Yes, it's March the 21st. No, absolutely not. Nobody hasn't came and talked to me. They never even asked about my witnesses. Not one time in any conversation that we've had have anybody asked me about my witnesses.
Well, the only witness that you will need and have for the notice for the motion for new trial hearing is me with the affidavit. That's why an affidavit always have to accompany a motion for a new trial. Now, let me just tell you this, like I told you before. I can't see myself. We still live, but I can't see myself. I froze up. So, but I'm gonna keep it running because I'm not really concerned about the image. It's the audio exactly. So, let me ask you this here. When you going forward, let me ask you this here. Can you think of any reason why let me ask you this here. When you got arrested, is it are you in a room somewhere? I can't hear you.
Was I alone?
Yeah.
Yes. I was on my way to work.
You're on your way to work.
I was on my way to work.
No. That ain't what I'm asking. I'm saying, why is there so much noise in there?
Oh no, everybody's right here. Got the door open. Everybody's playing cards, talking.
Okay, well let me ask you this here. Okay, I just want to see that. I need to make sure you can hear me. Listen, like I said, it's not on the docket. I got the court order where it's a hearing. Now, this is a hearing on the 21st to determine if the court is going to grant you one. But let me tell you like this here. The evidence and the fact states that the judge must, it's her discretion, but what the law says, she abused her discretion when she arrived at a decision contrary to the facts in the law. So based on the law and the facts, the judge would abuse her discretion if she failed to grant you a new trial. But let me tell you what's going to happen even if you get a new trial. They intend to convict you, and they intend to give you an attorney who will be ineffective. And I'm going to tell you what this attorney game plan is that when you have a new trial. First of all, they're going to try to tell you that they don't have to talk to me. Okay, but this is what you need to understand. Any attorney coming forward once you get a new trial, his job, see, the only thing that this court can do, and they trying to avoid this here, is dismiss the case with prejudice. Now, I'm going to tell you why they're not going to try to do that and why they're going to try to get around that. But before I do, let me tell you why they can no longer prosecute this case. First of all, the facts of this case indicated that the judge, the prosecutor, and the appealing attorney, Matthew Seymour, had I not stayed on his back, they all intended to violate your rights to due process for two reasons. And I don't care what nobody says, I'm well acquainted with the facts. That's why I was able to call every step in to protect your rights. It's embedded in three things. Racism, a custom practice or policy to convict people, to clear the dockets. And number three, because they don't want everybody to know that the Dallas County criminal courts are in human trafficking. I'm going to break that down in a second. See, if you look at the facts of the case, if the DA, your attorney, and the judge all on January the 18th, before the trial began, the last day of the trial, before all the evidence was heard, they tried to trick you into signing a document saying that if you get found guilty, you can't attack the criminal conviction with new evidence. They was basically saying you couldn't even attack it because what they were trying to get you to sign was a plea bargain and you wouldn't even know it. See, and now, the problem with that whole scenario is they had your court-appointed attorney helping them. So if Philip Boyden and a DA and a judge is doing this to you, and they already saying by their actions that they don't have a case. You understand?
Right.
So moving forward with this, if they grant you new trial, the first thing your attorney is supposed to do is file a motion to dismiss your indictment. Let me ask you something. How long was you locked up? Because I have to go back to the docket. How long was you locked up before you indicted? Do you recall? If you don't recall,
yes, I believe I was indicted. If I'm not mistaken, I was indicted November 18th of 2022.
When was
I was maybe a month and a half. I got arrested on September 26th of 2022.
Okay. Now, let me ask you this here. There is nothing in the docket that indicated that your attorney filed motions that's worthy of anything. So once you got arrested, in since you never made bond, they had 3 months to indict you, and they had 6 months to take you to trial. They didn't do that. So what Philip Boyd did with the prosecutor as well as the judge, Philip Boyden waived your right to a speedy trial because he wanted you to plead guilty. Can you still hear me? I can't hear you. You answer me. I'm having. Can you hear me? Yeah, but sometimes when you talk, it sounds like you far away, like you're rasping. So I need to be able to hear what you're saying.
Okay.
And so and sometimes y'all need to coordinate up there and tell them clowns to sit down with all that noise up in there. Check this out. When your attorney get on your case, you need whenever they give you a new, and I'm gonna tell you like this here, moving forward, you're not obligated to sign anything any attorney, any judge saying, hey, if you don't sign this here, we're not going to get a hearing. You don't have to sign nothing. All right?
Okay.
Because anything you sign is questionable because you don't know what it is and you don't know how they're going to use it. Just like they tried to get you to sign these documents with all these pages, then when you start reading it, it's saying that you can't attack your criminal conviction based on the evidence, discovered evidence. No person in their right mind will sign that unless that's a plea deal being given to them and they don't know it. Now, what I'm telling you is that it's pretty noisy up in there today. Can you hear me?
I don't know. They ask you, trying to ask more for something, but you got to scream through the window because they can't hear. They can't, they ignore you.
Okay, let me ask you this here. This is what I want to impart on you. When they hire you a new attorney, they are looking for this attorney to do the bare minimum. First of all, your attorney will need to call your mother Lily Siles. Are you still there? Uh-oh. Hello?
I'm here.
I think somehow I tripped the power. Hello?
I'm here, sir.
Okay,
I
think I tripped the power with my speaker.
Oh.
I don't know how that happened. Okay, but the first thing you need to understand is that the attorney coming on your case, should they grant you a new trial, he's looking to do the bare minimum. But what's more important, he should file a motion to dismiss the case for prosecutor misconduct, malicious prosecution, and on the grounds that you can't get a fair trial because their minds are already made up. See, you had the first trial where nobody testified to the facts in the indictment. What they did, they just gave a broad spectrum, so you can't defend yourself with a broad spectrum of testimony that don't bear on the facts in the indictment, because the indictment is your opportunity to prepare a defense. Now, here's another problem with your case going forward. When you go forward with this here, once again, I'm gonna tell you like this here, I fear for your life and sanity because you said when they first convicted you, they put you in suicide watch, right?
Yes, they did.
Now I ask you, do they do everybody like that up there when they get convicted and put them in suicide watch?
Now that's what the guard told me. That everybody that gets over 20, they gotta go to suicide watch.
Okay, could you next time at some point I advise every prison up there to send a kite and ask them to show you the written policy for this, because I don't like that scenario, because if how do you determine that a certain amount of time warrants putting a person in suicide watch if they don't have a suicide history? Why are you putting them in suicide watch? But let me tell you what I think they're gonna try to do. If they find you guilty, they're gonna give you more than 35 years. But I'm pretty sure that we can get a not guilty verdict. I'm pretty sure that. Now, but what I'm telling you, what you up against, see, your trial attorney ain't on your team. I'm the only one on your team. Well, this is why they tell you they don't have to talk to me. Well, if you tell them to talk to me because you don't trust them, see, you got every reason not to trust them, because see, the way this whole trial went from the beginning wasn't supposed to happen. So it's a custom practice to policy what they doing. And so this new attorney, whoever he is, I don't care how they talk, how she talk, you can't trust them, because see, they sleeping in the same bed. You black, you don't know the law. They work with each other every day. So, and like I said, everybody going through that trial court and some other trial courts up and down, they got their mind made up to find you guilty. Period. Now, moving forward, what you think is gonna happen? Just what you think. We just procrastinate.
Well, what I think is going to happen is that they're going to see, what they did wrong, and they're going to overturn my conviction. And then when the jury hears all the real facts, that
Okay, hold on. No, see, you got the wrong concept. But I asked you what you think. They're not gonna let the jury hear all the facts. See, that's your attorney job, and your attorney ain't gonna do it. If you don't have an attorney present and represent you right, they ain't finna hear shit but a narrative of what they want. This is why you need to have a clear understanding that they still looking to convict you. They want to make an example out of you. So don't get into that fairy tale that you think this is gonna happen. I'm telling you what's finna happen. They finna give you an attorney, just like they gave you Mr. Barton to try to cross you out. He's gonna give the appearance of representing you.
Okay.
Do you understand?
Yes.
So now this is what I'm trying to tell you. This is what I'm telling you. Your attorney's first job is to file a motion to dismiss the indictment based on prosecutor misconduct, based on judicial corruption. It's all there. And so when that attorney, when you asked him to file this motion and he don't do it, that's when you know this man is not representing you.
Okay.
So now they looking to convict you because they trying to make you look bad. They want to try to make people think contacting me won't do them no good. But guess what? Like I said, they can't go forward with a prosecution because the facts indicated that you didn't have a case. You didn't have a case. They use your attorney to convict you. And they'll do it again. If they did it then, they've been doing it. Do you understand?
Yeah.
I'm telling you, the Dallas County criminal courts are human trafficking. And they do that by doing what they did to you. They need them bodies in prisons. They need those certificates and bonds on Wall Street. Your cattle. Everybody in prison is livestock. Don't get it twisted. That's why they call them. That's why they grow their own food. They work it. It's stock. This is why they don't care about your rights and your facts. It's a business. This has been proven. Your appealing attorney, Matthew Seymour, even after you filed a motion for new trial, tried to get around a motion for new trial. They was forced to file an amended motion for new trial and incorporate it because your motion for new trial and my affidavit was the only correct form, and that's that. And so they had to incorporate that. So I'm telling you, you got a hearing for motion for new trial based on your pro se motion. But they looking to make an example out of you, so they want to make you think that fighting ain't gonna do you no good. But well, guess what? If your motion for new trial had not had the evidence, and this is why I got out there with McCall, because I know what it takes to get a motion for new trial. Your word against his alone, you wouldn't have got it, okay? Because it wouldn't have been no evidence. So now, if your attorney, Philip Barton, who swore to uphold the law and represent his to represent his clients, didn't do it, if the judge took an oath to uphold the Constitution and be fair,
you have 1 minute left.
Go ahead and hang up and call back.
Okay.
All right. I'm gonna tell you like this, people. She got it. I think it's. I hope y'all. Cause I can't see y'all because I'm frozen. Y'all still. I don't know if y'all can see this here, but because I can't see it. But she has a hearing on March the 21st for this motion for new trial. I know they hate to give this hearing, but that's just the gist of the matter. And so what's going on here, Matthew Seymour on the 29th of last month called Omni Williams' mother, Lily Siles, the person made the charge but didn't testify, and told her that they got to give her a new trial. Well, why is her appealing attorney calling? That's the district attorney is supposed to call them. That was their witnesses. But this time...
Hello, this is a free call from an incarcerated individual at Dallas County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions. number as a private number. To accept this free call, press 1. To refuse this free call, press 2. Thank you for using Securus. You may start the conversation now.
Hello?
Yes, hello?
Okay. Back, I went to it. Okay. What I'm telling you is this here. All the evidence is there. When this case is, they listen to these videos like they listen to your phone call. Here's another most important thing your attorney must do. He must file, when this case is reversed and you get a new trial, the judge, your attorney, Matthew Seymour is not going to be your trial attorney. You understand that, right?
Yes.
They're gonna get you a new, and when he come in, because see, they want to make it look like they had a case by getting a conviction again. See, you can convince a jury to convict anybody, but I got a game plan for this next trial. See, your attorney's supposed to file you need to take notes later on, but we'll touch base. You don't have to take the notes now. Your next attorney should file a motion to recuse Judge Tracy Holmes. Recusal motion. She can't hear the case. She can't hear the case. I think she would withdraw on her own, but as your attorney to fulfill effective assistance of counsel, he still must file a motion, argue, and get a ruling on it, because there is the appearance of biasness, and there is an overt act of biasness, because you stated in real time that when you was convicted, Judge Tracy Holmes turned to the prosecutor, Kaylee Rodney, and say, see, it's easy. See, it's easy. Now, why would a trial judge turn, an unbiased fact finder, turn to the prosecutor and say, see, it's easy? What she was saying, see, it's easy to convict these people up in here because I'm going to help you. Your attorney going to help you. We're giving you everything in place to convict them. Only thing we doing, we giving it the appearance of due process. Well, now, remember the recusal motion. Now you're gonna get your attorney. He gonna do the same thing as Philip Boyd, but this time what they gonna do? They gonna falsify log sheets like they coming in seeing you. See, this is what they finna do. I'm telling you, fuck the log sheets, fuck all that. I'm saying when you send him a letter telling him the motions he needs to file, when he don't do them, same thing. See, they want to keep your letters from coming out, because now you got a track record of what you're telling your attorney to do. And when he don't do it, that's what they call ineffective assistance of counsel, because everything you're telling them is what an effective counsel is supposed to do. See, your word alone, if you tell your attorney something and you can't prove you ever told him to do this, so you're fucked. So this is why I tell people, create the paper trail, and that way it's going to help you in the future. So, like I said, moving forward, they don't care about let me tell you something. Like I tell you, I'm going to say it on here. They mad because you black. That's just one of the aspects, people. And if you think racism don't exist, that's you. I know it exists. I see it every day in home appraisals. I see it every day in the courtroom. Y'all know what I'm talking about. So if you're saying it don't exist, you're saying poverty don't exist. Yeah? All right then now. Now, check this out. Moving forward, like I said, they want a conviction again. But guess what? Like I said, the evidence ain't there. See, everything they said in the last trial can be used against them to impeach them, to cross-examine. Now, your attorney, Matthew Seymour, just like your attorney, like I said, I don't know what they're going to do. All I'm saying is your motion for new trial, you got a hearing. The hearing is not the new trial. Don't get that confused now. The hearing is just to determine if the judge is going to grant it. Okay? So don't get that twisted. Now, if they get you up in there, like I said, I think they're gonna start trying to falsify your signature on anything, because we already got established you ain't signing nothing, you don't trust them. But like I said, they want you to be convicted because of my social media page. See, if I didn't have the social media page, I don't think I could have just achieved this with just without it, because it's after. Okay, if I didn't have the videos, I don't think it would have been an uphill battle, okay? And so this is what they're upset about, okay? And so they want to get a conviction from you to say, then I have to come on here and tell them, oh, they gave the Army 99 years. Well, guess what? I'm gonna tell you like this here. We're gonna fight, but at the end of the day, I'm gonna tell you like I've been telling you. It'll be up to you to take a plea, but I'm gonna tell you like this here. I would never take no plea on no sexual assault, no rape. I'll take a plea on a murder. I'll take a plea on a Ponzi scheme, but raping and anything else, I ain't trying to hear that. It's just it's a stigma that attaches to that you don't want. See, people can accept a mass murder living next door, but they have a hard time with a sexual predator. You see how that is?
Mm-hmm.
But I would want a mass murder next to me. But see, I understand how easy it is to convict people on these charges like you. But that's why I asked you on the day of the trial, who testified to the facts in that indictment? And nobody. But like I said, they use your child. What's them organization name?
Alliance for Children.
Alliance for Children.
New Life.
Alliance for Children and who?
New Friends.
New Friends. New Friends, New Life. They got these organization people. Remember these names. They've been around for quite a long time. They work with the police and courts. They're supposed to be unbiased forensic investigators. Well, the problem with that is this. Oh, here's another thing. Let me shout. Omni Williams, I was thinking about this last night. Your attorney supposed to file a motion to get the grand jury minutes and proceedings, right? We need to know who testified in front of the grand jury to get this indictment. You understand?
Oh.
Okay, so your attorneys didn't do this. See, somebody had to testify. We need to know the substance of their testimony, okay? Because if Lily Siles testified, which I'm pretty sure she did, at the grand jury hearing, and we need to know who the prosecutor presented that evidence, then we want to know why Lily Siles wasn't called. We want to know what was actually said there and compared to what they said at the last testimony. And this is what they're afraid of. This is why your lawyers never tackled this. Any lawyer, look here, I'm going to tell you like this. I'm going to tell all you lawyers something dealing with Omni Williams' case. If you bring your motherfucking ass to the table and you're not filing a motion to recuse the judge, motion to dismiss that indictment for prosecutor misconduct, judicial conduct, and malicious prosecution, you are crossing your client out, and I'm coming for you. I'm coming for you with the full force of the law. Okay? The minute you step wrong, I'm going to step on your head. I'm coming. See, I already know, y'all know that if an attorney do what they supposed to do, damn near 99% of the people will walk the fuck up out that jail room, and y'all don't want that. Like I said, Philip Barton, at every step of the proceedings, engaged in a constructive denial of effective assistance of counsel. And I asked him with his own words, why you never filed a motion for a speedy trial? And he answered twice saying, it's as speedy as it gets, speedy trial, 3 or 4 years. Then he said it wouldn't have did no good. So what? So you waive Omni Williams' right because it wouldn't have done no good? Man, you incompetent. Corrupt too. Like I said, we're gonna be in touch. But like I tell you, I can't determine once they give you this motion for new trial. I think they're gonna try to put drugs in your food, use the guard, mess your mind up, and give you something that'll. I'm telling you, they planning on killing you. That's what I think. Now, a lot of people think that's strange, but they did it to Epstein. But I'm telling you, I know how they work. This is why I knew what it takes to get out there and get the evidence to expose it. I would watch what I eat when you down there in the tanks and stuff with the judges and them. Drink plenty of water before you come down there because they'll give you something to make you spasm out. And next thing you know, they'll say you killed yourself. They'll give you a drug that make you bang your head up against the wall till you kill yourself. They are upset because what I'm saying the truth. I said they have a custom practice or policy of using your own attorney to convict you. And they doing this to everybody down there. Mm-hmm. They doing it. Now, I can't even go on the website. I don't know if they got my internet access, like the location, but I got a plan for that. So when I do it this other way and I still can't log in and see these cases, it's okay. It's okay. I'm going to file a lawsuit to make them open up that portal again because you're discriminating. You got it. It's a public access portal. I've been accessing it, but there it is. Right. See, they upset because they want they using your rights. They using these positions. Everybody, see, here's the thing. We have a presumption of innocence. The judge is supposed to presume you innocent. But here's another thing. You said a judge at one point called you out with your lawyer and asked you if you're going to take a plea. You remember that day?
Yes, that was June 27th of 2023.
A judge is not supposed to discuss a plea with you unless you took it. See, this is what I'm saying. The judge was engaging in judicial misconduct. If you look at the Kohlberger case, people, the judge or any of these cases you see on social media that's high profile, unless they came to an agreement, why is Judge Tracy Holmes discussing a contract that she has refused to that she rejected, saying what? Just tell me what she was saying on that day.
Okay, well, I'm sorry, I misspoke. That was July 3rd of 2023.
Okay, that's fine.
It was July 3rd, 2023.
Okay, what?
So on that day, she was behind the bench, and me and Philip Martin were in the little leather chairs right behind the table, not at the table, behind the table. And so then, that's when he told me that they wanted to give me the 15 years. Am I going to take the 15 years? He asked me all of that over again. So I said, no, absolutely not. I'm not taking 15 years for something I did not do. Okay, so then that's when they asked, was the DA there? And the DA was not there. So the judge came down from behind the bench, came through the little door in the wall, came outside, went through the little swinging door, went past those benches outside of the courtroom into the front court, the front offices right there. Okay, I don't know if she went in the hall or where she went. She came back in. She stood directly in front of me, in between the table and the leather chair that I was sitting in. She asked me, am I going to take 15 years for this charge? I said the same thing I said to Philip Martin. Absolutely not. I'm not taking 15 years for something I did not do. She said, okay, we got to set it for trial. She turned around and she walked back behind the bench.
Okay, stop right there. See, that was improper. That was a deprivation of due process. See, the judge was acquainted with the facts and the circumstances even before she heard the case. So her mind was made up. See, when they freely engage in this conduct, they realize that the defendants don't understand that it's improper and it's corrupt. So like I said, I don't care what Philip or Matthew Seymour or anyone I'm saying. This time it won't be a conviction because guess what? Here go who you need to be calling as witness. You need to call your attorney, Mr. Phillip, as a witness. See, I'm going to show you how I would attack this case. And this is how you should have been attacked. And this is what your attorney. But your attorney is going to get around. Philip Boyd need to be called a witness. Lily Siles. Everybody that's Detective McCurney. Everybody that did the forensic interviews with your child. How many over the years? See, they did so many interviews with your child where they was molesting her mind and creating this stuff. Because like I said, these allegations happened, but you was indicted and arrested 2.5 years later. None of that makes sense to me. So from the time your mother made these allegations, it was no probable cause. They created probable cause through these two organizations. And this is what they do. This is how they convicting people because if they allegedly said that you did this when this child was 11, right? Now, you go talk to any 11-year-old child. Is your daughter suffering from a mental illness? Is she retarded or slow? No. Okay, so she ain't none of that, right? So people, they already know it's gonna be proven. See, your attorney never called any experts. He never called no experts for you. But not only that, he should have. Your child was 11, so what's the problem saying, hey, Lil Sue, Lil Johnny, Coco B. World, did so-and-so do this to you? That's a yes, no, a child gonna know that. That child is at an age where she could say that. So they are used, that's the evidence, people. My grandson just left. I asked him how old he was. I think he said he was, I think he said he was 5. He can talk good. He know he can do everything. So this child was 11. And you tell him now, say, hey, come on, people. Come on. See, it don't make sense. So if you look at the facts today, if I walk outside and I slap an 11-year-old child, you think that child gonna have enough sense to say, Mama, he hit me? Yeah. So we already see they created this evidence this is why I say they're human trafficking, because we need to know how many interviews that the Alliance for Kids and New Life. We need to know how many of you jackasses and how. See, here's the thing with this. Even the Texas statutory law and other laws, they create this protection where the interviews, like the video interviews, they don't have to get them to you. They don't have to let you see them. Now they can let you see them if you act like if they want you to, right? Well, they saying this to protect the child, but see, let me break something down to you people. Remember, I told you that the presumption of innocence is bullshit. Well, if the presumption of innocence is really exists, why we can't see those forensic video interviews? Because this is an allegation, but you hiding it saying that it's true. See, the presumption of innocence is straight bullshit. And this is where they getting a lot of people. Because if we presume to be innocent, you cannot be a victim. You're an alleged victim. But ladies and gentlemen, like I said, this is supposed to happen at 11 years old. The child is 15 today. So you mean from 11 years old, 12, 13, 14, 15, 4 years, this happened. But see, Lily Sal's, your mother, that's the secret. That's your key to your freedom, because it's going to be shown that from the time she made these allegations, from the time of the investigation, there was no probable cause. The probable cause was created. The fabrication was created through the forensic interviews. And that's what a problem is at. Because if the mother word alone didn't exist, did not have enough evidence to bring a probable cause to an existence, it exists. But here's another thing that they was trying to cover up. When Omni Williams' mother made that complaint, they asked her, did you see this? She said, no, my daughter said it. Well, if your daughter, I think that's your granddaughter. If your granddaughter told you this year, you the witness. But everything keeps changing. But see, when this is how they doing it, people. They taking you through these forensic, they taking a child through the forensic interviews to make it appear like professionals developed the facts. No, you didn't. Because if you gave more than 2 interviews, it's a problem. What they do, they keep giving these interviews, then off the record, when ain't nothing rolling, like when I turn this off, they talking to her, well, we can get you all type of help and this and this. We just need you to just open up and say, if this happened, we got these things we can give. We got money, we got programs. This how they doing this shit, man. This is how they doing it. This is a scheme. And ain't all these lawyers, they not speaking up about it because these businesses work with the police. Why would the police need these people to interview them? Don't the police got enough skill, detectives, to do this? Come on, man. Ray Charles can see this. I'm half blind and I can see it. So what they doing, this is what they hide. This is why when they had the trial, that Detective Burgern, I could have slapped the shit out of him. He got on the stand and lied. Because I'm gonna tell you, I'm gonna put it like this here. Just like Reba McEntire said, that's the night that the lights went out in Georgia. That's the night that they hung an innocent man. This is what the fuck going on down there. It ain't never stopped, people. We are fools to think that racism and corruption with these judges has stopped. If the killing, the raping, the fraud ain't commit, the same thing happened on the street is happening in the courthouse. But the problem is everybody keep thinking that these judges and lawyers doing their job. They ain't doing their job. I'm gonna keep that attention. I'm gonna keep that spotlight on them. I just wanted to get that take on that, Omni. But let me tell you something. Moving forward, you have to watch yourself. They want to see you dead or convicted. So don't be surprised. Like I said, everybody on that tank, or get a lot of people, find out where is the policy of putting people in suicide watch if they get 20 years or more. What is that policy based on? Because you can give a person 5 years and they'll go kill. It don't make sense to me. That don't make sense. But I'm gonna reach out to Matthew. I'm gonna be reaching out to Matthew Seymour this month, and I'm also asked him, what is this policy? But I won't hold you up. I'll let you get on. I mean, matter of fact, I need you to call me. Anything developing, always call me. But do give me a call Tuesday. Anytime Tuesday. Matter of fact, Tuesday about 12 noon, we can discuss what need to be going on moving forward and what we can expect. So I won't hold you up. You have a nice day.
You too. Thank you.
My camera is froze, people. I really can't see. I can't see myself moving, but here's the deal, people. She has a motion for new trial hearing March the 21st, 2024 of this month. They hate to do this. They was trying to get around it, but my constant videos showing them that her motion for new trial is the only valid motion and attached with my affidavit. Any other motions are frivolous and must be denied as a matter of law because they're not in proper form. And so if that was the way I was showing them the logic that all this was done to get around the valid motion. This is why all y'all motions are invalid. You was trying to prevent this woman from attacking what y'all knew to be true. And so even when they brought in Matthew Seymour, and that's why I'm letting them know, they keep telling Omni, well, I'm a witness. I'm acquainted with the facts of this whole case. So I am what you call a bedrock witness to this case, because guess what? Other facts was developed in this case dealing with the judge, the prosecutor, her attorney, and her appealing attorney, okay? And her mother, and the organizations that testified. So you can't move forward because I'm a main witness. In a minute you deny me from testifying, you also violate her right to due process. So that's why I say a conviction this time won't happen. And if it happened without me testifying, see, you know, if I testify, I bring them facts. See, the videos, you know what? I can't see myself right now. I'm going to stop this live. I'm going to come back with another live in about an hour, and I'm going to break it down. Now, I already told Omni she got to watch out because at this point, they want her dead. They want me dead too. See, it's easy for them to get to her because they can poison her food, etc., etc. But I'm going to sign off, and I'll be back in an hour. Thanks for tuning in.